Good afternoon. Thank you for joining us today. My name is John Sherman. I'm the litigation director at Fair Election Center and lead counsel for the plaintiffs in Lostutter v. Kentucky. My colleague Ben Carter from the Kentucky Equal Justice Center joins me here, and you'll hear from two of the clients, Derek Lostutter and Bonifacio Aleman, as well as one of our former clients who regained his right to vote, Stefan Harbin. Ben and I will speak, then the clients will give their statements, and then Ben and I, and only Ben and I, will be answering questions after all statements. We're not going to give the governor a free deposition here, but we can, after the fact, set up one-on-one interviews with our clients after the call, and our folks can be in touch about that. Please feel free to share questions in the Q&A function as you go, and after all statements, we'll answer questions. So today was a good day. After 4.5 years of litigation, 2 dismissals from the district court, now on a second trip up on appeal to the U.S. Court of Appeals for the Sixth Circuit, the courts have finally reached the merits in our case. We have challenged Kentucky's arbitrary system of voting rights restoration for people with felony convictions as a violation of the First Amendment. The easiest way to describe what we're challenging in Kentucky is to ask you to imagine a different, fictitious world in which the only eligible voters are those from whom government officials arbitrarily select without any governing rules or criteria. Obviously unconstitutional, right? No question. And you didn't hear otherwise from Governor Beshear, the district court, or the court today. No one would ever argue such a system is constitutional. And also, selectively withdrawing the right to vote without any rules or criteria is also obviously unconstitutional. But the district court and Governor Beshear have taken the position that our client's case should come out differently, because here a government official is arbitrarily and selectively granting licenses to vote to people who are presently ineligible to vote under state law. They say our claims fail because Kentucky law designates voting rights restoration as part of the pardon process. In essence, they have asked the court to decide this case based on the prefix re in re-enfranchisement. The problem for Governor Beshear is that for 85 years, the Supreme Court of the United States has prohibited laws that give government officials absolute discretion to grant or deny licenses to engage in First Amendment protected activity, which voting is. While there is not a specific case applying this longstanding doctrine to arbitrary voting rights restoration, the same principles and concerns that animated the Supreme Court's rulings in this area over the last 85 years are all implicated here as well. An arbitrary licensing scheme, such as Kentucky's, creates the risk of undetectable viewpoint discrimination. Governor Beshear may review the prior political expression of restoration applicants, and nothing in Kentucky law prevents him from factoring that in and denying an application because of that person's likely viewpoints and votes. This, the First Amendment forbids. Today, the court heard as clear a violation of this First Amendment doctrine as anyone is likely to encounter in the year 2023. Governor Beshear's counsel said that the standard for deciding voting rights restoration applications, FATES, is whether the governor deems the applicant, quote unquote, worthy. When pressed by the court to define worthiness, Governor Beshear's counsel could not and did not. When asked whether Governor Beshear uses any criteria to make these decisions on restoration, his attorney said no. Most states in the country have entirely moved away from discretionary restoration. 40 states, including Texas and Georgia, I'm rarely in the position as a voting rights lawyer saying, just do what Texas and Georgia do, but seriously, just do what Texas and Georgia do, plus DC, all restore voting rights immediately upon the completion of incarceration, parole, and/or probation. Kentucky is one of the last holdouts in the nation that forces disenfranchised people with felony convictions to seek the blessing of a government official in order to regain their right to vote. One day, I truly believe, whether it happens in this case or another case, this practice of arbitrary restoration of voting rights will be struck down as unconstitutional. Governor Beshear could end this case today. He could extend his existing executive order from late 2019, literally 2 days after he took office, to all people with felony convictions, not just those with certain Kentucky offenses. He could craft a different, non-arbitrary system. Instead, he and his lawyers are in court fighting for sole and unchecked authority to grant or deny licenses to vote to the disenfranchised. Why? Lastly, let me make one point not on the law. Not only is Kentucky's restoration system clearly unconstitutional, but it is deeply un-American to force people to beg for their right to vote and to have one government official evaluate their worthiness to regain their vote. Clemency, that is the pardon power, is something we inherited from the English monarchy. Today, in the year 2023, in just these last few states with governors and other officials clinging to this power, the pardon power has been perverted and weaponized to disenfranchise large populations of otherwise eligible voters. The Sixth Circuit has an opportunity to begin the process of dismantling this unconstitutional and un-American system. Now you'll hear from our co-counsel, Ben Carter at Kentucky Equal Justice Center.
Thank you, John. Thank you for today. Thank you for all the hard work you've done over the last 4.5 years in Kentucky and in Florida before that, and Virginia now, and all over the United States to protect fundamental fairness of our voting system. The Kentucky Equal Justice Center has been working in coalition with many grassroots partners for years on the problem of felony disenfranchisement in Kentucky. We are one of the worst states in the nation on this issue. And like I said, we are grateful for the hard and careful work of the Fair Elections Center, all the work they've done to give the courts the opportunity to strike down the arbitrary voting rights restoration process to which we currently subject Kentuckians seeking their right to vote again. While Governor Beshear's executive order in December of 2019 made 147,000 Kentuckians with felony convictions in their past eligible to vote, a report from the Kentucky League of Women Voters from January of 2021 found that Governor Beshear has also left behind another 178,000 Kentuckians who have felony convictions in their past, but have completed those sentences and still have to apply to be worthy, based on his sole discretion, of the right to vote. Governor Beshear has decided to make each one of them individually apply to his office for restoration of their voting rights. And today we heard Governor Beshear's counsel tell the court that the governor has not made a decision on whether or not to grant or deny two of our clients' pending applications, pending for years, one since December of 2020, because thousands of other Kentuckians have also applied for restoration of their voting rights under this unconstitutional scheme. That's how important this case is. Beyond the shocking number of people still disenfranchised after completing their sentences, 178,000, presumably each month, more people complete their sentence. So that was 178,000 just in January, as of January of 2021. Beyond that number, the league also found that 15% of voting age Black Kentuckians cannot vote because of a felony conviction in a person's past. This is compared to 6% disenfranchisement rate for all voting age Kentuckians. So more than twice the rate of disenfranchisement for Black Kentuckians because we over-police and over-prosecute those communities. I encourage everyone listening to this now or later to read the league's report. You can find it at bit.ly/LWVKY 2021. As John said, though, judges aren't the only people with the power to fix this problem. Governor Beshear or the legislature, the Kentucky legislature, could act to protect people hoping to vote again from arbitrary state action. We are asking Kentuckians who care about this issue, KEJC is asking Kentuckians who care about this issue to take action by emailing the governor and their representatives in Frankfort to encourage them to do what they can to fix this problem. The link to take action is bit.ly/KY-voting rights. We'll put the link in the chat since I garbled it a little bit. You can encourage Governor Beshear, like John said, to expand his executive order to cover people with felony convictions in other states, people with federal felony convictions, and people with convictions for violent crimes here in Kentucky. Governor Beshear left all of those folks out of his executive order. You can tell your legislators in Frankfort to put a constitutional amendment on the ballot so that people immediately get their voting rights after they've back after they've completed their sentences, no matter who is Kentucky's governor. The link again is bit.ly/KY-voting-rights. Again, I want to say thank you to our incredible co-counsel in this case, John and everybody at Fair Election Center, and to our clients who are doing everything they can to ensure that all Kentuckians are treated fairly and welcomed fully into society when they've completed their sentences. It's a true honor to be a part of this case, and I hope that I know this is part of the work of getting Kentucky in line with better practices all across the nation.
Thank you, Ben. I will now pass it to Derek Lostutter, the lead plaintiff in this lawsuit.
Hello, everybody. My name is Derek Lostutter. I am the lead plaintiff in this lawsuit, and I will preface my statement with the fact that Governor Beshear's executive order did reinstate rights for certain felons that are state, not federal, but not out of state felons. And that is one of the common issues in this case that becomes a nexus of claims. But thank you all for being here today. And we gathered to discuss a vital case in Kentucky, which is Lostutter et al. V. Commonwealth of Kentucky. And that revolves around the restoration of voting rights to individuals with past felony convictions. Again, I'm Derek Lostutter. I'm a paralegal. I work in law, who previously served a prison sentence after violating a federal anti-hacking law. Despite serving my time, I, like many others with federal felony convictions in Kentucky, still face indefinite revocation of my voting rights. I'm one of many citizens affected by a policy that excludes people with federal felonies from immediate restoration. A policy that unfortunately places Kentucky at the bottom of voting rights restoration. The importance of an objective and transparent and neutral process for restoring voting rights in Kentucky cannot be overstated. No government official should have the power to pick and choose who gets to vote. This process must be devoid of subjective bias and not discriminate on the basis of political viewpoints. My case was a violation of the Computer Fraud and Abuse Act. That's a federal law that some believe has been applied too broadly due to its vague wording. The controversy around this law highlights how technological advances can complicate legal landscapes and begs the question whether cyber-related offenses should fall under the same category of felonies as violent crimes when it comes to voting rights restoration. It's important to note that my actions, though illegal, were not violent in nature. Kentucky allows people with non-violent felony convictions to have their voting rights automatically restored upon completion of their sentences. But like I just said, just state, not federal, and not out of state. Yet federal offenders like myself are left in an application-based process that is inequitable and non-transparent, requiring a governor's blessing for re-enfranchisement. Despite my very active participation in political discourse and a commitment to public service, I am unable to vote in the very systems and policies I speak on, a situation that starkly highlights the unfairness of Kentucky's current voter rights restoration process. Not only does this application-based process disproportionately disenfranchise those with federal felony convictions, but it also leaves room for political biases and potential First Amendment violations. I'm gonna take a moment to pause. I stutter, my bad. The lack of clear, uniformly applied rules guiding the governor's choices and the absence of a required time frame for decision-making effectively grants an unfettered power over a citizen's right to vote. Our democracy thrives on the principle of equal representation. Every citizen, after serving their time and paying their dues to society, deserves the right to participate in the democratic process. Arbitrary disenfranchisement undermines the efforts of rehabilitation and social integration and is a blemish on the face of our democracy. Through reform, we can ensure a fair, neutral, transparent process that restores the voting rights of those with past felony convictions. And let us not stand as one of the very last states in this nation denying the basic right of democratic participation to our fellow citizens. I thank you for your time.
Thanks very much, Derek. I will now pass it to Stefan Harbin, one of our former clients who has since had his voting rights restored.
Good evening, everyone. Thank you for joining. I think it was the great historian Lord Acton who said absolute power corrupts absolutely. And I don't believe that absolute power corrupts good character. I do, however, believe that absolute power has the potential to reveal a person's true character. And it enables them to exercise an agenda based on pre-existing beliefs and political interests and personal biases rather than the will of the people or the rule of the law. I believe in the importance of political participation in order to make one's community a better place. And for years after I served my sentence, I was stuck on the sidelines of our political system because of my record with no way to have my rights restored. And while Governor Beshear chose to restore my rights to vote in 2020, what if he decided not to? What if his successor decides to withhold the restoration of voting rights for people who look like me or who are in similar circumstances as mine? This is why we have to continue to push to remove any and all barriers that limit or prevent us from exercising our civic duty to vote and be heard. We as free citizens should not be subject to the inconsistent, uncertain, arbitrary will of any one government official. Any decision concerning the freedom and liberties afforded us by the United States and the Kentucky Constitutions should not be based on individual discretion, but on the fair application of the law. And for me, this is not about politics. I don't care if you're Democrat or Republican, because I personally refuse to be pigeonholed to any one political party. For me, this is about fairness, transparency, and ensuring that everyone knows what they need to do to regain their right to vote after completing a sentence for a felony conviction and to re-enter into society. And until a clear, objective process for restoring voting rights is written and established in the law of the land in Kentucky, we and so many like us will continue to be subject to the whims and will of individual politicians whose hearts and minds do not always necessarily serve our best interests. No one, and I repeat, no one should have absolute power over whether any one of us gets to participate in our democracy as full citizens. Thank you for your time.
Thanks very much, Stefan. Another one of our plaintiffs who is currently seeking the restoration of his voting rights, Bonifacio Aleman, couldn't be here today, but he has shared a recording of his remarks, which we'll play now.
Hello, my name is Bonifacio Aleman. I'm a fellow Kentuckian, and I'm also disenfranchised and still do not have the right to vote in Kentucky. I'm also a community organizer. I work within the trust of communities all across the Commonwealth. I wanted you to know that I'm an active parent and a member of my community. I volunteer, I serve, and I am part of a healthy democracy without the right to vote. I'm a social worker. Since my time of incarceration, I've earned an undergraduate degree and a master's degree in social work, and I'm 1/3 of the way completed on my doctoral social work degree, all done since my release from captivity. I one day hope to apply for my social work license, something I cannot do without my voting in civil rights restoration. I'm also registered with the Kentucky Legislative Review Commission as a lobbyist through my job as an organizer with Kentuckians for the Commonwealth. As a registered lobbyist, I spend a lot of time, well, I am able to spend time in the Capitol talking to legislators about policies that will affect Kentuckians across the Commonwealth. In my capacity since my release from prison, I've led multiple public policy campaigns that resulted in community change. And the main thing that I wanted to get across to folks today is that I believe that I deserve the right to vote. I believe that all Kentuckians should be part of a healthy, unrestricted, and thriving democracy. My application to the governor for my voting rights has been submitted a couple years ago to no avail.
Thank you to all of our current and former clients who spoke. It's been an honor to represent each of you in this case, and an honor to stand with all people with felony convictions who are struggling to regain the right to vote and who are subjected to this arbitrary process. With that, we're going to transition to our Q&A portion of the discussion. Due to the ongoing legal proceedings, as I mentioned, all questions are going to be answered by myself and Ben Carter. Please feel free to submit your questions into the Q&A box below. I'll read out the questions that come in for us. I see a bunch have come in already, and we'll provide some responses. We might not be able to get to everyone's questions, but we'll fit in as many as we have time for this afternoon. And we'll also be distributing a recording of this conference and release to all of you. So feel free to respond to that email with any follow-up questions that you might have. So just to dive in, I see a couple already. So what do we expect next in the case? That's an easy place to start. Next step for the case is going to be a ruling from the U.S. Court of Appeals for the Sixth Circuit. When that comes down, it's impossible to say, but that will dictate the future course of this litigation, depending on what happens in that ruling. Of course, the appellate panel is 3 judges, so even a split 2-1 decision is a victory. We'll see what happens though, and we won't be getting into what next steps might be beyond that. But obviously, the Sixth Circuit is, not the last. A panel of the Sixth Circuit is not the last stop on the road. Proceedings can go. Not saying anything about what our strategy might be or what other strategies might be, but there is also an option to go to the full Sixth Circuit, all the active judges. That's called an en banc proceeding. And then, of course, there is the U.S. Supreme Court if they took a case on a petition for cert. What is the application? Someone asked, what is the application process like for those who are not eligible for automatic restoration under Beshear's executive order? How long does it typically take to receive a pardon when they are granted? So a couple things first, and one just at the outset, we don't consider these pardons, right? They're not pardons. This is voting rights restoration. It is one of the effects of a pardon, but you don't need a pardon to regain your right to vote in Kentucky. What you need is voting rights restoration. The Kentucky courts and actually one of the statutes have tried to split the difference and call this a partial pardon, which sort of has the oxymoronic ring of old news or something. But it's not a partial pardon. I mean, it's not a pardon at all, right? I mean, 40 states, like I said before, 40 states in the country deal with voting rights restoration totally separate and apart from the clemency and pardon process. There's nothing inherent about voting rights restoration that makes it part of the pardon process. It's a choice that some states, of very, very few states that are clinging to this power, have made. Right now, the application process is someone submits an application to the Department of Corrections. The Department of Corrections reviews that application for threshold eligibility, right? Do you meet the basic criteria of having completed full sentence, including parole and probation? And if you meet those threshold eligibility criteria, then it's forwarded to the governor's office. As I've been told, this is not part of the record in the case, I've been told no application has been granted since 2021. Many applications have been filed since then, thousands. As the governor's council said today, there are thousands pending. And those thousands of pending applications have had no action. I've never heard, someone can correct me if I'm wrong, I have not heard of a denial of the voting rights restoration application, but they languish at the governor's office, and it's shameful. But beyond shameful, it's illegal. Right? The second claim in our lawsuit alleges it is also a First Amendment violation to have a total lack of reasonable definite time limits by which the governor decides whether to grant or deny a voting rights restoration application. Right? That too is a First Amendment violation, because it just as much creates the risk of viewpoint discrimination if you can speed up one application process and slow down another, et cetera, et cetera. So we don't, in answer to the second part of that question, we don't have good data on how long it takes to receive a voting rights restoration, a grant of voting rights restoration. And it obviously varies by governor. They have totally absolute unchecked discretion under state law to do what they please. And Governor Bevin did a different thing. Governor Steve Beshear did something else. And it is sort of a black box, right? These applications go into a black box, and it's hard to know what to do with them. So this next question, I'm going to kick over to my colleague, Ben. Have your clients or organizations received any pushback from the Beshear campaign, the Kentucky Democratic Party, or other allies of the governor for pushing this issue amid the 2023 gubernatorial election?
Well, the short answer is no. The longer answer is we've been pushing this issue much longer than the 2023 gubernatorial election. This case started in 2019. Matt Bevin was the original defendant. We sued him because he refused to implement a voting rights restoration application process that contained neutral, non-arbitrary criteria that people like Derek and Bonifacio and Stefan could look at and decide whether or not they would or should apply to it. And that would constrain their discretion somewhat. Matt Bevin was the original defendant, and this isn't a partisan issue. Andy Beshear is a defendant because, like Matt Bevin, he has also refused to implement a neutral, non-arbitrary process for restoring people's voting rights.
One other thing to note just on this point, right? I mean, come December of this year, we might have a new defendant in the case, depending on how that election goes. But for us, it doesn't matter who the defendant is. The legal principle, the constitutional principle is exactly the same. We could come up with different hypotheticals all day of what might be disfavored speech or disfavored speakers for each of these governors, but it doesn't matter, because what is problematic, what's a constitutional violation here is the total lack of rules and criteria in Kentucky's voting rights restoration system. Next question, what is the status of each plaintiff in the restoration application process? Derek has not applied for voting rights restoration. Stefan has been restored, as you heard before. And so the other two plaintiffs, Bonifacio and Rob Langdon, who couldn't be with us today, Bonifacio and Rob have pending applications before the governor, and they've been pending for years. Bonifacio's has been pending, I think, for close to 3 years, maybe 2.5. And I think Rob's is even earlier than that, but they've been pending for years. Since executive orders are inherently less permanent than official legislation, but permanent restoration of rights would require a constitutional amendment, what is the ideal solution you see to this issue? Ben, I think this is one for you as well.
Sure. Like I said in my prepared comments, KEJC has been working on the issue of restoration of voter rights for people with felony convictions in their past for years with dozens of grassroots organizations across Kentucky. You heard Bonifacio say he was an organizer for Kentuckians for the Commonwealth. Kentuckians for the Commonwealth convenes a coalition of organizations that actually should be meeting right now, but is instead attending this event instead of their monthly conference call, and working on this issue. And ultimately, whoever asked this question, you're right. The right, long, and permanent solution to making sure that people who have completed their sentences get their voting rights back immediately after completing their sentences are welcomed fully into society once again is a constitutional amendment. And so the best way to get involved in that work is to write a letter to your legislators and to the governor asking them to take action. That will give us your contact information, and we will connect you with that coalition that's working each month, every legislative session, every season of the year, to make sure that the 178,000 Kentuckians who have completed their sentences and want to vote again get a chance to vote again, subject to a neutral, fair process that everybody understands and can participate in. So that's sort of, yes, the courts can fix this in the short term and could go a long way with an order regarding the constitutionality of the of subjecting voting rights to the whims of an individual government actor, individual government actor's determination of their quote unquote worthiness of a voter as a voter. The courts go a long way to fixing this, but to protect Kentuckians long term, we need a constitutional amendment.
So someone has asked, do we know the breakdown racially, geographically, et cetera, of the unsigned voting rights applications, and how many are there exactly on Governor Beshear's desk? The short answer is we don't know exactly, right? All we know is what Governor Beshear's counsel said today, which is thousands, right? I mean, there are thousands, and who knows, maybe that could even mean tens of thousands. But there are thousands of applications pending at the governor's office. And we don't know the demographic breakdown of those applications. There was no discovery in this case. Discovery was requested and denied. Again, we don't believe discovery or facts evidence was necessary to win this claim. This is a violation of the First Amendment on the face of Kentucky law. But we did ask for discovery and were denied that. So we don't have information on what happens inside the black box of the restoration process. All we know is what the governor's counsel said today, which is that their standard is worthiness, worthiness for restoration. We know, someone asked, we know that any expansion of the governor's executive order will still only be a short-term solution. But if the Sixth Circuit rules in your favor, does that mean that Section 145 of the Kentucky Constitution is immediately nullified, as will be such provisions in other state constitutions? So a couple things on this. One, we haven't won. We haven't won anything. We argued today, but there needs to be a ruling in this case. I can speak, though, to what happened in another case that was very similar. We filed a similar lawsuit in Florida, and we did win in district court. And what the district court did is, after finding liability on First Amendment grounds, gave not just, it wasn't just the governor there, it gave the Executive Clemency Board, all 4 members, including Governor Rick Scott at the time, the opportunity to come up with a non-arbitrary restoration system. Unfortunately, the injunction we won was stayed at the very last minute as they were about to adopt something closer to a non-arbitrary set of rules. And then we were up on appeal, and then it became moot because the constitutional amendment in Florida was adopted. Here, I imagine if we were to win on the merits of the First Amendment argument, something similar would play out, right? The governor would be given an opportunity in the first instance to come up with a constitutional restoration system. I don't worry. I think there was a version of this question earlier. I don't worry about Governor Beshear, or really any governor that we sue on this constitutional grounds, withdrawing, becoming the only governor in the country to permanently disenfranchise every person with a felony conviction with no way back. I don't worry about that occurring, right? So we can only do better, I think, with a win in this case than we can only achieve a better world than we have right now under the status quo. I think any governor would look at a ruling in our favor and come up with a constitutional set of requirements, fulfilling the terms of one sentence is an objective requirement. There's nothing automatic. I don't like the phrase automatic restoration. There's nothing automatic about completing all terms of one sentence, including parole and probation. That's objective requirement enough, and that Governor Beshear could roll it back to that, and that would be good. That would satisfy the First Amendment, and the case would be done. He could do that tomorrow. He could do that tomorrow, and the case would be moot. Why do you think Kentucky is one of the? Oh, sorry, there was one other part of this question. There are some other states, none as bad as Kentucky and Virginia, both of which my organization, Fair Election Center, is suing over this issue. But there are some other states that still have discretionary, arbitrary voting rights restoration. If this case were to make it to the US Supreme Court, and I'll leave it at this, all of those states would be implicated by a US Supreme Court ruling on this issue. But that's as much as I'll say at this point on that. Why do you think Kentucky is one of the last holdouts on this issue? Ben, you want to field this one?
Sure. Having spent the better part of 2 decades thinking about watching one state after another make progress in this area, and Kentucky being one of the worst 7 states in the nation, one of the worst 5 states in the nation. Then it's down to Iowa, Virginia, Kentucky, and Iowa's Republican governor does the right thing and institutes a better process. Virginia's Democratic governor institutes a better process, and then it's down to only Kentucky. I've been wondering this. Mark Twain once said, when the end of the world comes, I want to be in Kentucky because it's always 20 years behind the rest of the world. And that's where we are in this case. And I think that, to give a non-smart aleck answer, I think there's a misperception from people in power, both Democrat and Republican, that this issue is politically toxic. This is a legacy of our sort of tough on crime, war on drugs, practices of the 80s and 90s that we recognize didn't make people safer, didn't improve people's lives, and just led to a over incarceration of our friends and neighbors. So the fact is that if the legislature puts a constitutional amendment on the ballot in Kentucky to restore people's voting rights once they have completed their sentences, polling shows that it will pass. This is not, and not just with the support of Democratic voters, not just with the support of Republican voters. This across party, regardless of party, is a popular notion. Everybody knows somebody whose life has been affected by drugs, poor decision-making when they were a young person, whatever it might be, who is trying to do what everybody on this call is doing. You heard from Bonifacio. Bonifacio is literally a board member of the organization that I work for. That's what he's doing in our community right now. And yet the governor has not determined that he is, quote unquote, worthy of voting, having done more than enough to to satisfy any objective measure of worthiness. Yeah. Anyway, that's a long way of saying that I think that our politicians do not understand that the polling on this is actually very positive, and that it is not a toxic issue the way that they believe / fear it might be.
Thanks, Ben. Just to interject one good source for anyone writing on this issue, I dropped this in the chat. I think it'll be dropped in the chat. This is a report from the Sentencing Project. It's an update of their state-by-state estimates. In addition, just the national landscape, so everyone can see the good progress that's been made over the last handful of years. Every time I look at this chart, table 1 of the chart in the Sentencing Project's report, it gets better all the time. It's the rare state like Kentucky that is stagnant or going backwards, or Virginia, which is going backwards. Just to note too, right, just this year, New Mexico and Minnesota have enacted new rules, new statutes that have restored immediately everyone in the state who was on parole and probation. That just happened within the last handful of months since January 1st. So one other question. Someone asked, right now, would it be legitimate for Governor Beshear to expand or widen the portal opened by his executive order? So a couple of points on this. The existing executive order 2019-003, which was issued in December of 2019, only restored voting rights to people with specific Kentucky offenses, right? It excluded people with specific Kentucky offenses. It completely excluded people with out-of-state convictions like Bonifacio and people with federal convictions like Derek, right? So all of those people are left out in the wind and subjected to this arbitrary restoration process. A new executive order could be crafted and issued within a week that created the exact same rules for everyone, right? He could even do Governor Kim Reynolds, which for whatever it's worth, I will note, she's a Republican, over in Iowa, has done quite a bit better than Governor Beshear, and has issued an executive order that no one has challenged. All it does is it restores everyone with a felony conviction immediately upon the completion of their sentence. And the only people it excludes are people with the most severe offenses under Iowa law. And there is no lawsuit pending against Governor Reynolds. We're here in challenging Governor Beshear's policy in large part because he's left something like anywhere from 127,000 upwards. That estimates from many years ago. So the number's probably quite a bit higher today. So we're out of time. I want to thank everyone for participating in this call. I particularly want to thank Derek, Stefan, Bonifacio, Rob, all the former Rob Langdon, and all the former clients. We had 8 originally when we filed this lawsuit against Governor Matt Bevin. A lot of the writing on voting rights and other civil rights litigation makes it sound like the lawyers do the work and stick their necks out and go into court and get yelled at and get peppered with questions. But at the end of the day, it really is the plaintiffs who make historic landmark litigation possible. We hope that this case will be, and our plaintiffs have stood up for a fair and non-arbitrary voting rights restoration system. And we truly believe that this is an unconstitutional system under the First Amendment, and that one day it'll fall. Thank you again for everyone for coming and participating, for your interest in this incredibly important issue. I'm sure we'll have other opportunities to speak about it in the future. Thanks again.